Welcome to a special episode of Beyond Four Walls, where we delve into the world of property management and well-being. And in this episode with Emily Gray, we're tackling one of the most understood documents in property management, which is the lease. Leases can feel dense, repetitive, and full of legal language that makes your eyes glaze over. But within those clauses sit the answers to so many of the questions we deal with daily. Who is responsible for what can be recovered through the service charge, and what rights and restrictions apply. We'll guide you through how to approach reading a lease with clarity and confidence so it becomes a tool rather than a headache. The information shared in this episode is provided for general educational purposes only and should not be considered legal or financial advice. Property law and leasehold arrangements can vary depending on the individual lease, building and circumstances. If you require specific advice relating to your property, lease or responsibilities as a director or leaseholder, you should seek guidance from a qualified legal professional or specialist advisor. So today we're talking about reading and understanding your lease in terms of the leasehold perspective. Why is understanding the lease so fundamental for management agents and for leaseholders?
The lease is your Bible, really. It is what tells you how you own your property. So when you've got your flat, how long do you have it for? On what basis do you have it? Who is your landlord? What are the things that you've agreed to? What are the things that your landlord's agreed to? It's a contract at the end of the day. In simple terms, the lease is a contract. So in the same way that you enter into a contract for your mobile phone, you enter into a very similar contract for your property. But there's quite a lot of significant implications in that contract. So it's really important to read your lease. And exactly as you say, to understand it.
Yeah. So what are the key elements of the lease? As a leaseholder, whether you're a first-time buyer or you're a seasoned leaseholder with multiple flats, what are the key fundamental sections or clauses that you should understand within the lease?
So your lease, they come in very many different formats, but they will usually take the same very rough structure in that they'll set out the particulars. So which property does this relate to? Who's the landlord? Who's the leaseholder? Other parties? What term is it held for? And what rents are payable for it? Then it'll go on and it'll say about the landlord's obligations. What does the landlord say that they'll do? What rights are accepted from the lease and what are afforded to the lease? And then what are the leaseholder's covenants under the lease? What does the leaseholder promise to do? And I think from a leaseholder's point of view, that's the key part. What have you said? What have you signed up to under this lease? Have you promised that you won't have any pets in the property? Have you said that you will pay your service charge 6 monthly based on a budget? So understanding those covenants within the lease is key, as well as the description of the demised premises. So what is yours under this lease? What has been given to you for your sole occupation by the landlord? Does it include the balcony? Does it include the patio? What is yours? What is the landlord's?
Okay. And so two leases can sometimes be different for the same block.
Yep.
Why does it matter that every lease ultimately should be the same, or what are the implications of them not being the same?
So usually when we take on a block, we would read a sample lease and hope that everything else is drafted on the same basis. Usually there'll be a clause in a lease that says that the landlord undertakes to grant other leases within this building on the same or similar terms. And that's really helpful to know, because then that does mean that if flat 5 can't have pets, we can assume that flat 10 can't have pets as well. But if you only have flat 5's lease on file, and you have a query from flat 10 about something very specific, and they're perhaps arguing that they believe they are allowed pets, I would always suggest pull flat 10's lease off land registry so that you can read it and check that it's not different. Because I have seen, especially where we have a lot of buildings where it was a house and it's been cut up into different flats, and they've maybe been changed at different times. And it hasn't been done through a nice structure where there's an RMC that's formed and leases are granted all at the same time. It's an individual landlord who's perhaps been living in the ground floor flat, has granted a lease to the top floor flat, then decides, well, I'll sell the ground floor flat and I'll grant a lease on that. And I have seen leases where the year end is different for the top floor flat to the bottom floor flat,
Right.
where the service charge percentage is different, where the description of the building is different. So it's kind of it's 4 flats, but one lease treats half the building as one, so they're obligated to pay one half. The ground floor lease treats the building as four, so they're obligated to pay one quarter. And that's an absolute nightmare. So usually we like to consider that the leases are the same, but if you have any queries or you're not sure, make sure that you review them all. And that can certainly be the case when you've got percentage payments set out in a lease. Make sure that you really understand what percentage everybody has to pay.
And in terms of when you take on a new development, either as a new property manager or a seasoned property manager, what tips would you give to approaching, reading and interpreting the lease of the building? Do you have a set structure, like, well, we're going to look at the obligations and write those out, or do you have a particular way of doing that?
Yeah, so we've got basically a form that says these are the things that you should be able to answer from the lease. So, does it allow pets? What is the demised property? What is the service charge year end? And basically, it's going through the lease to fill out as much of that questionnaire as you can, to then also reference the clause that says that, so that if you need to refer back to it to look at the specific wording, you can do. My top tip for leases is don't trust what someone else has told you. So if you take on a new property and it comes with this lovely lease summary saying, oh, this is the service charge year end, these are the apportionments, don't take that as gospel. Read it for yourself and check for yourself that you're happy that that's the case. Because ultimately, you will be responsible for that. If you're charging out on the wrong dates, as managing agent, it's going to come back on you. And it's not going to be any sort of argument to then say, oh, but that's what's always happened. Because you need to make sure that you know what the lease says.
And in terms of then, how does the lease sit within the wider legal framework alongside legislation and Landlord and Tenant Act and that sort of thing? Where does it sit? I know you said it's the Bible.
Yep.
The lease is another one I like, but where does it sit there?
So your lease is basically how you occupy your property, and it's very specific to your building, your property. Legislation is then overarching in relation to the sector as a whole, but generally legislation trumps the lease. So we're seeing now with the Renters' Rights Act being introduced, they're saying that tenants will be afforded more rights in relation to pets. Now, we're all very familiar with leases that say that you can't have pets other than with the landlord's consent, or you can't have pets. Well, if the legislation actually trumps that and says there are cases in which pets must be allowed in properties, and one such case is if it's an assistance animal, so if it's a guide dog, even if the lease says you can't have it, legislation says you've got to allow it. So there are elements where legislation will trump the lease. And there are elements where the lease will actually somewhat trump legislation if it's very much specific to how that building operates. So it's really important to have an appreciation of everything, because you then have the management agreement that sits alongside it. But that is only how you, as managing agent, manage the property. What you've agreed to do or not to do doesn't change what the lease or legislation says.
Okay. What happens when there's that conflict?
Get legal advice. I think we have to be careful as property managers to stay in our lane. So whilst we have an appreciation of the lease and an appreciation of legislation, we should not be saying to our clients, this is exactly how you must go forward, giving a determination when there is that lack of clarity. We should highlight that this is what we think, but this could also be the case. And I see that with saying who's responsible for the balcony. We can kind of look at it, and either it's really clear in the lease, which is always lovely when you get that, or you have to say that I think that the lease is trying to say this, but it could be saying this. There's a risk that if we go down this route, we are going to go against the lease. So let's go and get a legal interpretation, because then at least, if nothing else, you're putting it on someone else's public professional indemnity insurance. And that's a solicitor that's qualified to give that opinion, rather than us giving that as a managing agent outside really of our remit.
Okay. And what are some of the most common ways that leases can be misinterpreted?
Lack of grammar.
Yes.
I've had many a conversation with solicitors about the lack of grammar in leases. There is no punctuation whatsoever. But then a solicitor will argue that actually putting in a comma could completely change or create more argument about what the intention is. But you'll generally see in the demised premises just a long, very long sentence of what's included. And it will say this is included, but this is excluded, including this, but not that. And you come like, well, hang on, is it included? Is it not included? What is the leaseholder's property? What is the landlord's property? It's starting to get a little bit clearer, but when I read leases that were written in 1980, it can be really quite difficult to determine when your service charge year end is or how to interpret that lease. So there have been arguments for leases to be written in plain English. There have been arguments for standardised leases, but I think that because of the way leasehold is constructed and because every building is so different, that's really difficult to put into place.
Yeah.
The thing I like about a lot of new leases is they have headings, so that makes it very easy to scan the lease to say, oh, there's the pets clause,
Yeah.
rather than having to read it front to back.
Yeah. I find the misinterpretation comes in around maintenance. Like when you say that this is included, but that's excluded, and da 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 da. It's generally around, well, your maintenance responsibility goes up to this part of the wall, but then that part of the wall is somebody else, and therefore that's excluded, and therefore, but this is included, and it's incredibly confusing.
Yeah, and definitely around windows.
Yes.
You say that the window frame is the landlord's, but the glass is the leaseholder's. So if the window needs to be replaced, how do you approach that when the window is not entirely yours as the landlord to replace? Or if the glass is smashed, but then they need to affect the frame to put the replacement in, are they allowed to do that because that's the landlord's property? These things are drafted by solicitors who don't generally have to deal with these things in the practical way,
Yeah.
and sometimes haven't even seen the building, and that's where a lot of issues from leases can come up. I've had a lease that it was drafted, everybody pays 1/8, but there were only 7 flats in the building. So we then had to go back and get it varied, so that it was varied down to everybody paying 1/7.
So what is the process then if a lease is wrong? How does that work?
So the legislation allows us to look for a variation of leases, and there's 2 ways in which you can do that. One is Section 35 application, which is when a lease is defective. So in the case that I just gave, with there being 7 flats and everyone paying 1/8, that is considered defective because you are unable to recover all of the service charge, or you're looking to recover too much, more than 100%. So that's considered defective. Similarly, if there are maintenance obligations or insurance obligations which mean that you can't practically manage the building, it would be considered to be defective. So you can make an application then to the tribunal to say this lease is defective, it needs to be altered in this way to allow it to operate. Tribunal, can you decide that that's reasonable? If the tribunal makes that determination that yes, the leases can be altered like that, you go through a variation of the lease, which leaseholders have to prescribe to because it's been determined by the tribunal, and then you go forward and operate. The other one is Section 37 application, which is a majority application, where you need to have 75% of the leaseholders in support of what you're proposing and no more than 10% against. So that might be that my lease doesn't allow improvements. So we want to build a swimming pool, but we can't build a swimming pool. So we want to change the lease to allow for improvements. If you've got everybody on board, fine, you make the application, tribunal hopefully agrees in your favour, and you can go ahead and make those variations to the lease. So that's how you do it, by getting the tribunal application. The other way would be to just enter into a variation of your lease with your landlord. Now, the landlord has an obligation usually to make sure all leases are on the same basis, so they're probably not going to be able to vary your lease to say, yes, you can have pets, without doing the same to everybody else. So it depends on the circumstances of what variation you're looking for, and how that can be agreed.
So what would your advice be then if 2 parties interpret the same clause differently?
Get a solicitor's opinion or get a tribunal determination. We have had this quite recently where there was a lack of clarity over who was responsible for the balconies. And one party was saying, well, this clause clearly says that it's the leaseholder's responsibility. The other party was saying this clause clearly says it's the landlord's responsibility. And we had to go and get the tribunal determination on which was correct, so that then we can go forward and either incur the costs of the service charge or say that the leaseholders are responsible. It is a lengthy process to do that, but you risk that if you don't do that and you incur costs, you then may get a challenge against it, and then you might find that those costs are actually irrecoverable in service charge, and then you're in a really sticky situation.
Talking of costs, are there cost implications to varying or changing leases, whether they're defective or not?
If you're making an application to the tribunal, there are some minor costs. There are a couple of £100 for making an application to the tribunal. Whether you need the support of a solicitor for making that, by them helping you to draft what the new clause looks like and to get through the paperwork, then you obviously have solicitors' costs. When you're splitting that between all of the leaseholders, they can be quite negligible. But if you're looking for more significant changes, and especially if there's going to be a challenge around whether that alteration is granted or not, your costs can be a lot more significant. But it is weighing up, is the risk of doing this actually going to hinder me more than incurring the cost to get this done for the betterment of the building?
And can you give an example maybe of around where the misread clause has caused confusion?
Yeah, I actually had one the other day. There's a tool that will help you in reading a lease, and it'll kind of give you a summary of it, and you can ask questions. And my colleague asked it, can I raise a levy? Now, what they wanted to do was raise an additional charge in the year to fund some works. And this tool came back and said, yes, you can raise a levy. And if you'd read that on just the face of it, you might have gone ahead and raised that charge. But when you then read the explanation, it said that you can raise a charge based on a budget, and then after the year end, you can raise a balancing charge. And it interpreted that as the additional charge in the year. So you have to kind of think about, you have to look at the context as a whole. I do get people who kind of send me one clause from a lease and say, does this mean I can do that? You have to read the whole lease and everything around it to get the full determination. And that's, I think, the top tip for reading leases is look for capital letters. I know I said they don't really do grammar, but they do capital letters very well. If you find something like the word property in a lease and it's got a capital letter, that means it's defined somewhere else in the lease. So when it says the landlord is responsible for maintaining the property, and that's with a capital P, you want to look back perhaps towards the start of the lease, where you'll find a definition of what property is. And that property may be flat one. It may be flat one plus the garage, it may be flat one plus the patio plus the garage. And so then looking for those capital letters let you look somewhere else in the lease to see what the definition is, because they don't want to use the whole definition every single time. So look for your capital letters.
Good tip, thank you. And as a manager, where does your responsibility start and end when it comes to interpreting lease? You've mentioned getting legal advice a few times, but as a manager, where does your responsibility start and end?
I think we're responsible for helping to guide the client in relation to the lease. So we should be looking at it to get the basic terms from it. We're expected, and I think it's reasonable for us to be expected to have a good understanding of how a lease is constructed and on what basis we should be managing. Because, like I said, we've got our management agreement, but we are still agreeing to manage the client's obligations under the lease. So we need to be able to interpret those. But it is also our responsibility to identify when there is a lack of clarity in a lease and potential confusion over how something should be interpreted, and to then guide the client towards getting a legal opinion for some more clarity, or going to a tribunal to say that we're looking to do this. Can you confirm that we can do that and that those costs would be recoverable as a service charge?
Okay. And then how should agents explain their lease obligations to leaseholders who might not have read it or understood it? because as you said, it quite rightly said earlier, you are signing a legal document, you're signing a legal contract, but sometimes you don't read it before you sign it. And, I've seen it so many times. So where do you start by explaining that to somebody?
It's a difficult one because I've had it. Someone's bought a property, they've moved in with their dog that they've owned for 14 years, and then we've said, sorry, this is an absolute prohibition on dogs. You cannot have the dog. Well, my estate agent said I could. And then you have to explain it. Now, if I was to send a letter to you and say, in accordance with clause 3.2 and page 7 of your lease, you're not allowed to have pets. You must remove the dog, and we expect to receive confirmation in 14 days that that's been done. You're going to get that, and I would imagine your back's going to go straight up. You're going to start wanting to fight that. So it's looking at how you communicate that. You can still make reference to the necessary clause within the lease, but we have to remember that these are humans that are receiving it at the end of the day. They are people who have bought their home and who are looking at how they live in it.
And they're bringing their most treasured pet with
them. They
them.
are, yeah. And I mean, sometimes with the best will in the world, they are a little bit ignorant of what their lease says, because maybe they've lived in a freehold house for their entire life and they've been able to knock down whatever wall they want. And now they're downsizing, they're moving into a flat, and they would just really like to open up between the kitchen and the dining room. So they want to go ahead and knock the wall down. But actually they're not aware of the effect that has on the rest of the building, and that their obligation under the lease is to seek the landlord's consent prior to doing that, or that they're not allowed to do it at all. And ultimately those sorts of issues can end up in legal battles. We want to avoid that as far as we can. So it's about humanising the issues, having conversations, but drawing people's attention to what the issue is, and that it is actually a clause of a contract that they have breached that we need to rectify, and giving them ways in which that can be rectified.
Yeah. So what's the best way, do you think, then, to communicate that to leaseholders? Either do you do it at the outset? Do we work more with estate agents before it even gets to the point of sale? What are your thoughts on that?
For me, a lot of the responsibility should lie with the conveyancing solicitor. It's their responsibility to make sure that their clients, the prospective purchaser, understands what they're purchasing and what the implications are in that. So many times, though, I see that, right, you've been provided with a lease in this 400-page bundle of documents. Can you just tick there to say that you've read it and you've understood it? And that covers off the obligations. It's very difficult from a managing agent's point of view to be able to have those conversations, because we have so many new leaseholders coming in day after day, and normally by the time we know that they're in, it's about a month or so that they've been in, because we're delayed in getting the notice of transfer. And it's then, I would love to see from government a little bit more. They've got the how to rent booklet. I'd love to see more about, there is a how to lease booklet, but it's very out of date. More awareness of what purchasing a leasehold property means, how to interpret a lease, things to look out for, and ideally that summary of a lease. This is the summary. Again, this is the conveyancing solicitor for me. This is the summary of the lease. These are the main terms that you need to see. But there are tools out there that can help, that you can put your lease in now, and it will give you that summary. So again, there is some responsibility on the purchaser to make sure that they're aware of what they're buying.
Because as you said earlier, maybe you would enter your phone contract without reading it. I think we've all done the Apple, do you agree with the yes? But this is the most important thing you're probably going to buy in your entire life. This is the biggest asset that you own, but you don't read what you're actually obligated to do or not do.
Yeah, and I think that's kind of a cultural thing. And I know personally, I've probably ummed and ahed over a pair of shoes longer than I've ummed and ahed over whether I'm going to buy that property or not. And they're vastly different in the cost.
Yeah.
But I think when we're buying a property, we're focused on that being our home, and we can redecorate the lounge like this, and we can do this, and that's where I'm going to build my family. We're not concentrating on the legalese of it. And unfortunately, that's what can then come back and bite us, and it can really change the way in which you live in your home. because suddenly your home can be the cause of all of your stress and overwhelm if you are in a legal battle over having knocked down a wall that you shouldn't have knocked down, or over whether you have to remove your pet.
Yeah. I think that's probably the worst conversation for me, is the pet one,
Yeah.
because your pets mean so much to you.
Yeah.
You know, so it's so hard. But do you think there's any training and professional development that can help not just property managers, but leaseholders, resident directors, and anything like that that could make you feel more confident in reading a lease?
I think it's getting stuck in and reading some and starting to see and appreciate the wording that's in there and understand different ways of expressing things that do come out in leases. And if you can do that, it's a bit like learning a language, isn't it? The more you familiarise yourself with it and immerse yourself in it, the more you start to understand it. And that's what's so difficult. I think it's we can do it as property managers because we can sit and look at loads of leases, and that's part of what our responsibility is. But as a leaseholder, you have your lease for your property, and if you don't understand it and you're not sure what it all means, it is difficult to know where to go without spending a lot of money on a solicitor to help clarify it. But again, I will say that there are tools out there that can help. There is leasehold advisory services there to help with explaining difficult issues within your lease. And sometimes your managing agent might be able to help as well, just with a conversation with them.
Yeah. And in terms of leases, you mentioned earlier, like solution leases and sometimes the other way around. But how do leases interact then with changes in building safety and service charge recovery, maintenance responsibilities? How it doesn't seem to all add up.
Yeah, it doesn't. And that's been a lot of the issue that managing agents have had with the introduction of the building safety regulations and the obligations that there are now on the landlord to make sure that these buildings are safe. But there's not necessarily the correlating clauses within the lease to allow the costs of making those buildings safe recoverable as service charge. And so then that begs the question, well, who is going to pay for it? And if you are a resident-owned company, how are you going to recover those costs? If you're an institutional freeholder, maybe you have to bear those costs. But if you're a resident management company, the people who are part of that company are the leaseholders of the building as well. And leases, so again, I've referred to a number of buildings that we manage. They were built in 1980. The leases were written in 1980. They didn't even have any sort of inkling of what today's society might look like. They don't allow for improvements. They say that the cost of the landlord's reasonable costs of receiving a notice are 4 guineas and 2 shillings. Well, that doesn't really translate into current day economics. Or they are written that the service charge is paid in arrears because when it was written there was a freeholder who would front load the service charges, but now that's an RMC.
Yeah.
So again, that doesn't work. So it's important to look at how can those leases be updated, and that's through those applications to the first tier tribunal or going through a process collectively with everybody for surrender and re-grant of new leases, which can tie into lease extensions. So when you get a lease extended, you may update some of the clauses to make sure that they're a little bit more modern. But unfortunately, changes in legislation don't always mean that your lease follows and catches up. It can take a little bit more work to get your lease to where it needs to be.
And I suppose that applies as well to costs. So if a managing agent is doing something from a legal perspective in terms of the sales process, and the cost to do X, Y, and Z is this, but the lease says it's only £2.50. How do you manage the two issues there?
Again, with great difficulty of kind of saying, well, actually, the lease, I would normally look at it and say, well, the lease is only asking me to do this bit, and it says that my charge for doing that bit is £50. But what you want is actually a bigger part, and so my charge for doing the bigger part is my charge for my professional services. And so I can either do just a tiny little bit, or I can do all of the rest of the work as well. That's where we need to get paid for that. But it can scupper managing agents in terms of those sorts of fees.
Especially when you get the fee through on completion, if you like, comes through with a notice of transfer, for example, and you get this check for the minimal amount of lease because one, it hasn't been handled, it hasn't been communicated. We've communicated it as a management that these are our fees, but that's been ignored because the lease says X.
Yeah. And I see it all the time in notices of charge. There's one particular company that will always only pay what the lease says, or they'll pay what they think the lease says, even though the lease might allow for all such other sum as may be determined. And then you have a lot of work in trying to get your actual fee, or you have to turn around to your client and say, actually, in the management agreement, it is agreed that my fees for this will be X. We hope that they would be paid by the leaseholder, but where they haven't been paid by the leaseholder, assuming that then you've had the conversation with them about picking up the shortfall, then we need to charge it to the service charge, and that means everybody pisses out.
Yeah.
But I don't feel it's right that we as managing agents should have to do the work for free when our time is we still have to pay our people, we still have to pay our insurances, our rents and everything. So we do have to make sure that our time is valued as well.
Yeah, definitely. And speaking of, I guess, empowerment in that respect, how can understanding your lease empower you as a lease holder?
It certainly empowers you because then you know what you can do and you know what you should expect of your agent as well, of your landlord. That you know that if your lease requires that your budget is submitted a month in advance of your service charge being demanded, if it's not, then you can point out and you say, actually, because you haven't served that, I'm not obliged to pay you. It can also say, right, I know that my lease does not allow pets, so I cannot go looking for a cat or a dog or whatever. It lets you know that, okay, well, I know I need consent to make these alterations. So let me deal with that first before I go and pay for the planning and for the building regulations. So it lets you be more informed, to make more informed decisions, and to then be able to also call out bad practices, because I'm not going to sit here and say that every managing agent is fantastic. There are unfortunately bad practitioners out there. But if you are more empowered about what you should expect from your agent and from your landlord, then you can call out those bad practices.
Yeah, definitely. And so finally, as we finish off, what's one piece of advice you would give to both leaseholders and managing agents in terms of understanding and ultimately respecting the lease?
When I get a junior property manager starts with us who's perhaps never read a lease before, the first thing I do is say, right, here's 5 leases, they're all very different, have a read of them. Then I'll say, here's my lease summaries for those 5 leases. Now go and find where I've found the answer to each of those questions within those leases, so that you can say, okay, well, I have said this lease doesn't allow pets. Where's the clause that says that? Do you understand it? That can help with the interpretation of it. And then I'll say, right, here's another lease. Try and fill out that questionnaire, so that they know then what they're looking for. They've seen a few different examples of it. They may be more able to interpret it. For a leaseholder, it's very difficult because you perhaps only have your lease, but do have a look through it, try and understand it. Google, ChatGPT, they don't always get it right, but they can perhaps help you to interpret some language that you may find a bit more difficult. But ask questions as well if you're not sure. I think the main thing is have a go, but I'd say I've read more than 1,000 leases. I've read so many, but people will present me with a clause, and we'll have to have a conversation about what we think it means. There is no point, I think, and I would hope that solicitors would even say the same, where you go, I know, I can interpret any lease perfectly, because that's why we have courts and tribunals for solicitors to go at it against each other and argue the truss over what a clause means. So you're never going to be expert at it, but if you make yourself more available to looking at different leases, reading them, expanding your experience around leases, it can start to make a little bit more sense, in the same way that you start learning French. The more you kind of experience it, and the more you expose yourself, and the more you put yourself out there, the better you'll become at it. So do that with leases too.
Okay. Well, thank you very much for your time.
No problem. Thank you.